lead our discussion. Thank you very much for having accepted this invitation to join us today. I think it's the first time that we've got so many lawyers. Often we hear more from social workers and the medical side of things, but today we're talking about law related to children's rights, because that is the real foundation for all of our work. And we're going to launch a discussion. There's going to be a discussion with speakers. I'll intervene sometimes, and then after about 50 minutes, you'll be able to intervene in the discussion as well. So it's a new format for our presentations this morning. So let's get going. And I've got 3 questions to put, in fact. And then you're going to have a discussion on all of this. But right at the outset, I'd like to mention that children's rights, well, there was Dr. Janice Korshuk, who's been mentioned, but it was Dr. Henrik Goldsmith at the beginning of the century, at the beginning of the 20th century, in fact, who had already written down a list of 23 children's rights, not duties or obligations of adults vis-à-vis children, but rather specifically children's rights, their own inherent rights. First of all, the right to be born, and secondly, the right to be respected in their viewpoints, to be informed, and for their possessions and so on to be respected. And the 23rd right was the right to die early, prematurely. We were talking about during the war and just afterwards. That was the historical context. And then there was the convention that was established that's already been mentioned. And I'd like to put this question to you. Every day you're deploying all possible efforts to ensure that these rights are respected with policies and on the ground, and also from a procedural point of view. But what are the obstacles, the barriers, which mean that in 2017 children's rights are still not all being respected? And you can give it a whirl as you wish. Whoever would like to plunge in first, please go ahead.
Maybe I could start. What we see daily in our office, the advocate's office, we notice barriers that I would call cultural or related to policy. For example, very often we had the opportunity to introduce a very innovative framework in terms of child education, how to inform children about their rights. There is the model of the school respectful of the rights of the child. This is a UNICEF model, but when we met with school management and teachers, when we introduced the tool, they said, no, don't talk to them about their rights. They're already very difficult to control. So that is the child as a king. We will not give them even more rights. And this really reflects the Socrates quote from Nietzsche that it was presented on the screen. Over the centuries, we've had this idea that the children disturb people, they are dangerous, they're not respectful. And unfortunately, still they have there's this idea among people, that's how they are perceived. So also politically, we are doing things that of great quality insofar as the implementation of the convention. We're really following the directions of the committee on how rights should be implemented and respected. We developed a tool, a monitoring tool, data monitoring on the condition of children in the province. There's training also. There's a yearly training. This at the end of the year, this year, you're all invited to Moncton.
And of course, we'll be there to talk about the right of the child with experts from around the world. And we've developed a tool on the impact assessment on the right of the child. But in all this, Brian Gallant, the Prime Minister, the Premier, was there, as you saw in the video, to say that the right of the child is important. So I have to congratulate Dr. Julien's Fondation for the leadership role that they play, the political leadership that they... But I still have the feeling that it is not normally to the advantage of the politician to say that he has rights to do advocacy work for the right of a child. And therefore, we need to mobilize the political powers in favor of the child. It is not going to be Jerry or Samira who are going to be able to do that. It's going to be you. You do have to mobilize out in the field. That's what we have to do. And let's do it. Well, that's very interesting from a political point of view. We have a lot of obstacles, especially when we come up with the reports that you came up with, Christian. And so these are things that we know already. And in certain circumstances, in certain neighborhoods, things are very difficult. And Jerry and Samira, who work out in the field, and Jerry, you worked in the field as well, and now you're working at the university. The obstacles that you faced, what were they?
I do really think that there is a lack of cultural awareness of children as rights holders, and that as a result of that, there is a lot of resistance to understanding what that means, what that looks like. And I would also go as far to say that there are many people who believe that they are children's rights experts or advocates who are in fact not necessarily in tune or have a deep or rich understanding of what it means to empower a child to be a rights holder or to be a duty bearer to make sure that a child's rights are in fact being brought into fruition and actually demonstratable through their lived experience. And that's what we see. We see that there is this cultural problem within the legal system as well as within the various service providers that are engaged with the young people that we are working with, who are amongst the most vulnerable children that exist in our province. They're youth who are in institutionalized care settings in a variety of different ways. And what we see is that, when we have, education that we do in the community throughout the province about children's rights, what we see is that there tends to be this appreciation for children's rights so long as a child's viewpoint is consistent with what the adults think is best for them. So if the adults think that a child who's in care should live in rural Ontario without any access to basically anything, and the child says, I was born and raised in a large city center and I had access to all of these things and I'm going to lose that. If the adults think that the rural setting is best, we see that the child's voice in that circumstance very much gets pushed to the side. Whereas if the child was saying, yes, I want to go to a rural-based setting, everyone would say, look at this rights-respecting model. We have taken this child's view and made it a reality. And so what we see is this resistance to an authentic process for allowing a child to have a meaningful voice in processes that affect them. And that's by presenting the solution before they've had any input, or before we've done, that wonderful mandolin exercise of what the determinants for that particular young person looks like in terms of best outcomes for them. And I thought that was particularly poignant from the heart transplant diagram that we saw this morning. And so that's what we really see as the problem. And we see that specifically where we're finding that there's tension between power and control and rights. So we see that there's a problem child who is, as a result of their disability, potentially engaging in, behavioral difficulties in a classroom or group care setting, and as a result, there's repeated arrests, and we see that caretakers are saying, okay, they need to stay in jail, that's the solution. And that's about power and control. If they're in jail, they're safe. They're not safe in their home, they're safe in jail. And so we see those tensions. And so in Canada, there's been some shift in terms of framework to move against that, that logic of trying to contain as opposed to build capacities. But there is certainly the cultural shift that's lagging behind that, and is certainly where the nitty-gritty work has to be done, because taking a rights-respecting model requires time, effort, relationship building, and a real recognition of the ways in which the different caretakers and systems involved with that child have an impact on them. And certainly I think that Jerry was very good at pointing that out, that we don't often look at those spheres when we're in law, and so sometimes, as at Justice for Children and Youth, we don't get taken too seriously. We are kind of the airy-fairy people that come in and try and force the system of the law to take a broader look at what a young person's life looks like in the context of being in conflict with the law.
So my approach to this question is quite pragmatic. And the view I have is that a right is quite useless if it's not known about, or if it's not understood, or alternatively, if there's no forum to effectively pursue the right. And I think the first barrier, a very common barrier, is that for the people who look after children and for the children themselves, they often don't know that they have rights. In fact, the research into access to justice tells us that there's a prior problem. Before people fail to know they have rights, they fail to recognize that they're in a situation where rights apply. They fail to recognize that the situation could be framed as a legal problem, which means they fail to recognize that the machinery of the law could actually potentially be a support. So that's a knowledge and understanding are huge barriers. Secondly, even if that barrier is overcome and people recognize, yes, this is a legal right and it's there to be asserted, the whole question of how do I actually assert this right is a very, very complicated one. And either people don't know what to do with the right, or there is no available and effective way to enforce the right. The work that Samira and Christian do, these are wonderful resources, but in the grand scale of things, we don't resource this field very heavily. When I was in government, when I first went into government, we had a program of child advocates. And if there was a program that was cherished in government or more universally highly regarded, I've never come across it. And a few years in, the government announced a big 10%, 5% cut in the ministry's budget, and that program was one of the first things to go, which I think goes again to the issue of culture and our true valuation. Money is a very good measure of true priority. If you want to know how much government values something, just look at how much they fund it, full stop. That's where the rubber hits the road. So having the mechanisms, the machinery out there to help people actually enforce rights, children to enforce rights, especially vulnerable children, is a problem. The third one I won't say much about because you can guess it from my previous comments, but that's even if you get past those two barriers and you get into the system, you then have to deal with a system that's reasonably complicated and perceived by many people who are in it as overwhelming and hostile. And without a very effective champion to a Sherpa to help you climb Mount Everest, someone to protect you as you try and work your way through that system, it can be very, very demanding emotionally. Getting in is one thing, effectively getting through and out is yet another.
Peut-être que tu veux répondre.
Well, I just wanted to segue a little bit there from Jerry's comments, because I think the note about tracking, following the money is an important concept, and as a general measure of implementation under the Convention on the Rights of the Child, state parties are encouraged to have children's budgets, and there are places in the world where this process is working rather well. So the Danes in Denmark have models that Canadians should be looking at, so that you can have an annual fiscal exercise that will bring an accountability measure to how much are we investing in social pediatrics? Where are dollars for education going? If we had budgets allocated for child advocacy and they're declining, that there's transparency on that. Because those kinds of cuts actually, very often, the disparate impacts of fiscal decisions on children are not reported. It's a little bit of a shell game. And so you have to very intentionally pay attention to that, and there are processes that can support it. I wanted to mention too, just in terms of the systemic barriers that we face, they just a received way of doing things. So we went through a substantial reform of our youth criminal justice system. Two important reforms in the 80s, and then in the early 2000s we brought in the YCJA. And it was very much premised on global best practice around the world in terms of how to engage children and young people. We were looking at what Australia had done and what New Zealand had done. And New Zealand had gone from, being right behind Canada, because we were the country that had threw most of its youth in jail, more so frequently than almost anywhere else. And New Zealand was right up there. But they went from worst to first in terms of having the lowest rates of youth incarceration and the lowest rates of youth crime. And that's why we modeled our statute on that. And we developed this legislative framework, and we trained everyone on how to apply the YCJA. And then in some parts of the country, like New Brunswick, we just right on doing business the same old way we always did. We prosecute, and we try to get prosecutors to think that in youth criminal justice matters, case conferencing should be the model of intervention, that prosecution is really the last resort for the most serious offenders. But it's still a work in progress, to get the officials within the legal system, and including defense counsel, to be thinking this way. And yet we've seen in our work and our advocacy the transformative power of these processes. To Samira's point, that when I was thinking of a young person who's already post-sentence, post-charge, and is in receipt of an IRCS sentence. Now, IRCS sentence is an intensive rehabilitative custodial supervision order. And so it's supposed to give violent youth offenders the best chance for rehabilitation in community. But this young person poses such a threat within the close custody institution where he is held that he's isolated from contact from every other youth person. And that's been going on for weeks and months. And he's completely frustrated. And he's going to burst. And he's saying, I'm 18, transfer me to adult. Now, nobody thinks that going to, an adult jail is a good thing for this young person. But that's what he sees. That's the only light that he can see at the end of the tunnel, is get me out of here. And so that application, goes to court. And had that application been dealt with in the traditional way, the prosecutor would have, come up and said, we don't know why the, director of The warden is bringing forward the application. The defense counsel would have spoken against it. The judge would not have gone there, and the young person would have gone and, made a mess back in the institution. But we were able to convince the judge to go into a case conferencing mode and to hear the young person. And the judge was saying, I've been on the bench for 8 years. And this is the first time I've worked in this collaborative process with the psychologist, the psychiatrist, the intervention workers from the closed custody facility, the educators and social workers, and they came up with a plan that the young person is in favor of, and the young person was heard. So that's youth criminal justice the way it's supposed to work in a rights-respecting manner. It just doesn't happen that way in Canada far too often.
C'est exactement ça, en fait. Et puis, je voulais voir avec Samira parce que...
I wanted to see with Samira, and I'm glad that Jerry got into this as well, because Samira, you presented many children, and one of them went actually to the Supreme Court, or a youth of 17. And we're going to be talking about best practices, so perhaps you can tell us more about this case and what led this young man to go to the Supreme Court and why he was actually heard. And what did he say to the Supreme Court?
It was called Canthasamy, and Canthasamy was a case of a 16-and-a-half-year-old young man who arrived to Canada from Sri Lanka without his parents and was received by an aunt and uncle. And he had applied for refugee status, and his refugee claim was denied very, very close to when he turned 18. And so when his refugee claim was denied, he applied for what's called humanitarian and compassionate grounds. And essentially that application process is designed within the Immigration and Refugee Protection Act as one of the only mechanisms that directly calls for consideration of the best interest of the child. And in that case, what had happened is the decision maker received the humanitarian compassionate grounds application just before this young person turned 18. And in the course of making the decision maker said, okay, we're looking at the best interests of this child. We see that he's in high school. Well, that's what every child is supposed to do. We see that he has some friends. That's what every child is supposed to have. We see that he has, a loving relationship with his aunt and uncle that has some permanence. That's what we would expect for a young person who's lived here for a year and a bit. So we're just going to say, ultimately, he needs his parents, so let's send him back to Sri Lanka. And so it was just one of those poignant moments where here you have this legal framework of the best interests of the child, yet the application of it is so fundamentally against what the principle stands for. And so in that case, while we weren't directly representing this young man, we did intervene to participate as a child's rights expert in the Supreme Court process to highlight for the court how the best interest of the child principle is intended to be implemented. And truly the implementation of the best interest of the child is not intended to be a paternalistic process where we as the adults determine what's best for the child. It's about looking at the interrelated articles of the convention and how we can maximize the rights that are guaranteed throughout the convention in the ultimate decision that we are making. And so what we were able to articulate to the court was that when you are looking at a child's application for immigration status, the only decision that you are being asked to make is what's in the best interest of the child. It has nothing to do with anything else. It's about what's best for the child, and when you're looking at that, you're looking at the multiple factors that are impinging on a child's interest, like the way that children perceive time differently. So that year and a half for that young person was a lifetime. as opposed to what a year and a half may look like for all the adults that are in the room. And so we were able to make significant gains from that perspective in the court's understanding and integration of the best interests of the child in the immigration context. And we're hopeful that that will also help with the further litigation that uses the Convention on the Rights of the Child as a proper tool for making decisions that are rights respecting for children.
Exactement.